I don't know where you got this motion together, but basically it's case law that's strung along in definitions of, multiple definitions of corpus delicti. So that's why I'm asking you, tell me why you're wanting the court to dismiss this case. This is your motion, go ahead and argue it.
The motion speaks for itself, Judge.
Okay, sir, so then you do not have any argument, any oral argument on the motion.
I have nothing further to add. The motion speaks for itself.
Okay. State, do you have a response to this motion to dismiss?
Yes, Your Honor. After reading over it, it's, most of it is incoherent. It's vague. The one issue that may be proper and before the court is lack of jurisdiction, which the state feels this court definitely has jurisdiction. The actions are alleged to happen within the city of San Antonio, Bexar County, Texas.
Objection, point of clarification. Do you have any factual information, or are you just relying on the arbitrary opinion and asking the judge to deny the motion?
That's not any legal objection.
Okay. Sir, do you want to elaborate on your objection? I don't understand your objection.
Well, I'm asking if he has any factual information that he has to overcome the motion.
Factual information to overcome the motion to dismiss.
Yes.
Okay, so you do understand that, okay, so we're here for a motion to dismiss. There's an underlying case filed against you. I believe it is for, let's see here, disorderly conduct. Fact questions are questions that are answered at the time of trial. You do understand that. You're asking this court to dismiss this case, but what you're arguing is questions of fact are things that are actually answered during the trial.
I'm not asking for a question of facts to find any answer. I'm just asking if the prosecution has done a simple thing. Have they provided the court with any factual information that leads the court to believe they have jurisdiction?
This is a pretrial motion. They are not required to provide that at this time.
Then the motion is unopposed.
Okay. Hold on, sir. I haven't made my ruling yet. We're still in arguments on the motion to dismiss, okay? Okay, so that is going to be overruled. Carry on. State, do you have any other comments on or responses to the motion to dismiss?
The complaint is brought well within the time of the statute of limitations within the 2 years, Judge. And being that this is a Class C violation, or the 2 violations before this court for failure to identify this particular incident is a Class C, and the disorderly conduct that we're alleging is a Class C. Municipal court is a proper venue. This court does have jurisdiction over Class C in San Antonio in this court's record, so we are in the proper courtroom, Judge.
Okay. My understanding is the motion to dismiss is only on case number B1617598. That's the disorderly conduct.
Objection. That's supposed to go for both of them, but I didn't. There was some issue with the procedural effect in place that prevented any substantive access to getting it on file for both of them. The motion to dismiss should be relevant to both accusations that are here before the court.
Okay, sir, I only have a motion to dismiss for the one case.
Again, the procedural effect.
Hold on, I'm speaking. If you want to file a motion to dismiss for the companion case, you will have to do that. You will have to bring in a copy and file it the same way that you filed this one. But what I have here is only for the disorderly conduct. Okay, so you can go to room 131, pick up a copy of what the rules are as to how many copies you need to file, but you're not precluded from filing one on the companion case. Okay, so State, do you have any other response to the motion to dismiss?
Judge, outside of number 4, like I said, most of these are incoherent statements. And that's just regarding the motion to dismiss.
Okay, all right, so on the motion to dismiss, lack of jurisdiction, okay, so you're saying that it occurred here in San Antonio?
The state, Your Honor, is based on the complaint, the applicant is alleging that this occurred within the city of San Antonio limits within Bexar County, Texas. So yes.
All right, any response to their response? Sir?
I'm gathering my thoughts, once more, please. So the most speak for itself, that's all I have.
Okay, and as I said, I have reviewed the motion, I've made some marks on it, and basically the state has, my question was to the lack of jurisdiction argument, the other arguments that you make in this motion. Honestly, and let me just tell you this. In municipal court, the fines are pretty low. They are ranged from traffic cases are 0 to 200. Quality of life cases are up to $500 fines plus court costs. So in these courts, these are fine-only courts. They are not courts where you go to jail. So for that reason, you're not required to appoint an attorney for you, but you do have the right to counsel. I think you filed these motions on your own, so you're here making your argument. So I'm thinking that you are representing yourself.
Just a point of clarification, what do you mean by representing myself?
Well,
I'm here just trying to mitigate the damages.
You don't have an attorney, correct?
Is that all that it means? Is representing yourself that I don't have an attorney?
Correct.
That's all it means?
You're speaking on your own behalf. You do not have an attorney speaking for you. Is that correct?
I don't have any attorney at this point in time, but I don't waive any rights. I'm not making any declaration of representing myself. I'm just simply here trying to find out if I need to defend myself.
Let me finish what I was trying to explain to you. Because these are fine-only cases, neither the U.S. Constitution nor the state constitution require that we appoint an attorney for you. So you either represent yourself or you hire an attorney. I don't know where you got this motion from, but 1 through 3 do not make any sense, and they're not applicable to this particular case. I did give some consideration to number 4. The state has clarified that. The court does have jurisdiction because based on what the state is saying, this occurred within the 2-year statute of limitations. The allegation against you is a Class C misdemeanor. This is a municipal court. That's the kind of cases that we handle.
Well, that's not the only jurisdiction that I'm speaking to, and he's only speaking to one that he likes. There's a lot more in that motion. I feel that
hold on.
That motion has not been fully addressed.
Hold on. You're not listening to me. I just told you that the only thing applicable to this case is number 4. This other stuff, I don't know where you got this motion from. You might want to ask for your money back where you got it from, but it is not applicable here. The only argument that is applicable is number 4. The state has clarified that the court does have jurisdiction.
Objection, point of clarification. Just because they assert they have jurisdiction, does that make it true?
That's a question that the trial court will answer.
So what factual information has the prosecution submitted that leads the court to believe that they have jurisdiction that is defined as geographical location that the Constitution and statutes apply?
As I told you, those are questions that would be addressed at the trial.
Are you saying that it's only a matter for trial?
If you'll let me finish. Based on the argument that the response that the state has made to your motion to dismiss, I'm going to deny the motion to dismiss and
on what ground?
Go ahead and set it for trial.
On what ground?
That the court does have jurisdiction over this case.
And what factual information has the prosecution submitted has that?
Sir, I've already made my ruling. The motion is denied. We'll get you a trial date. You can argue that at trial.
Well, do I have the right to plead guilty here today, Judge?
You have a right to plead guilty. I'm not guilty.
Do I have the right to be informed of the cause and nature of the proceedings here today, Judge?
You know what you're cited with.
Judge, I was asking not what I was cited with. I was asking, do I have the right to be informed of the cause and nature of the proceedings here today? Yes or no?
I don't understand your question.
What part of it do you not understand, Judge? Do I have the right to be informed of the cause and nature of the proceedings here today?
Today, we are here for a motion to dismiss that you filed. We've just had the hearing on that motion to dismiss. That motion to dismiss was denied. We're going to get you a trial date.
Well, Judge, if my intention is to plead guilty here today, Judge, I just have a couple clarifications. There's no reason to go to trial. I don't know why you're speaking of trial when I'm still trying to find out if I can plead guilty. So why is there to speak of trial? I'm simply trying to find out. Again, question or the clarification on the table is, do I have the right to be informed of the cause and nature of the proceedings here today? Yes or no?
You've already been informed of the...
Objection, point of clarification. Regardless if you feel I am informed or not,
Judge. The judge says, okay?
I'm just trying to clarify, Judge. I don't think that you're grasping what I'm asking. I'll ask it again. I'm just simply trying to find out if I have the right to be informed of the cause and nature of the proceedings.
The cause and nature of the proceedings, you filed a motion to dismiss, correct? Yes or no? You filed a motion to dismiss.
That's a great point, Judge. We'll get to that. Again, I just need to get the clarification answer.
I'm answering your question.
Well, I'm just trying to find out if I have the right to be informed of the cause and nature of the proceedings here today. I don't see
Do
what's
you not understand what we're here for today?
I never said that, Judge. I'm simply asking if I have the right to be informed of the cause and nature of the proceedings. Yes or no? Simply yes or no will make things go along.
Okay, I've already told you. You filed a motion to dismiss. This is the hearing on that motion to dismiss. What part of the cause and nature of today's proceeding do you not understand?
Whether or not I have the right to be informed of the cause and nature of the proceedings. I just informed
you of what we're here for today. You filed a motion to dismiss.
But you're not telling me if I have the right to be informed here today.
What? You already know that you filed.
If what I want to be informed of right now is, do I have the right to be informed of the cause and nature of the proceedings here today?
Hold on, sir. I have already responded to you. The cause and the nature of the proceeding today is the hearing on your motion to dismiss. I've already ruled on that motion to dismiss. That motion is denied. We're going to set you for trial. This hearing is closed.
Well, Judge, you said I had the right to plead guilty here today. Do I not have the right to plead guilty here today anymore? When did I lose that right to plead guilty here today?
Nobody has said that you lost that right.
Then why are you trying to force me to trial and terminate the proceedings here today when I'm simply trying to get a self-clarification to plead guilty and go home?
So, you never entered a plea in this case? You refused to enter a plea?
Objection, point of clarification. My intention is to plead guilty here today. I have an unsigned plea of guilt that I will sign and hand over to the court, and we can go home. But I just have a couple clarifications.
Are you telling me that you want to plead guilty to the disorderly conduct case?
Because what I'm saying is my intention is to plead guilty here today. I just have a couple clarifications with simple yes or no, and then it'll be done. And the clarification that I require is, do I have the right to be informed as to the cause and nature of the proceedings? Yes or no?
I've already informed you of those.
Judge.
Okay, sir, let me tell you this. Let's make sure that we all have our roles correct here. This is the attorney for the state. Some police officer has filed some citation against you. You don't agree with it, and you filed a motion to dismiss. That motion was set for hearing. I'm the judge. You two are opposed. You want the state to dismiss? They don't want to dismiss it. They think they have a good case. You want it dismissed. You don't think it's a good case. I sit in the middle and I hear both arguments and I decide. You don't get to ask me questions, okay?
I'm not asking any questions.
I've already told you what the nature of the
I'm not asking any questions, Judge. I'm just simply trying to clarify
a few things. I've already
things.
told you that the hearing is closed.
Do I have a right to a fair and meaningful hearing here today?
You had your hearing.
Again, you're not being responsive to the clarification that I'm seeking, that I require, and the clarification is, do I have the right, or do I have the right to a fair and meaningful hearing here today?
You have had your hearing.
Judge, but regardless if you said I have my hearing or not, you're not asking if I have the right. I'm speaking to the right. Do I have the right to a fair and meaningful hearing here today?
You have the right to have your motion heard. It was heard.
So I don't have the right to a fair and meaningful hearing. Is that what you're saying? That
No,
I do not have the right to a fair and meaningful hearing?
No, I'm not saying that. You filed
Okay, so I do have the right to a fair and meaningful hearing. So
Okay,
would it
are
be
you
okay if
going
I
to
did
let
that?
me talk?
Well, I'm just trying to make sure that I'm clear and that you're not misunderstanding me. I don't know if there's a miscommunication or if my English skills are bad or not, but I'm asking a
I think
clear
your legal
question.
arguments are bad.
I'm not making any arguments. I don't know about what you're saying legal arguments, Judge. I'm simply trying to clarify a few things.
Is a bad argument. I've already.
Are you attempting to give me legal counsel by saying it's a bad argument?
No.
Okay, well then can I please just be informed
Okay,
of the
you know what?
consequences?
This motion, your motion is denied.
Judge, do I have
Do
the
you
right?
want a trial date or not? Either plead not guilty and set it for trial. You have not entered a plea so far. That's why.
Does this court accept uninformed and involuntary pleas?
Hold on. Would you listen to me for 1 second? You have failed to enter a plea.
Judge, I'm attempting to enter a plea. My intention is to plead guilty here today. Just got a couple clarifications, which you're not answering. So I don't know. I'm not asking any questions. I'm simply trying to clarify a few things. And what I'm trying to clarify right now is, do I have the right to a fair and meaningful hearing here today?
I've been hearing. You filed a motion to dismiss.
I'm speaking to the right, Judge. Do I have a right, yes or no?
Yes,
to
you do have a right to a hearing on your motion to dismiss.
Okay, do I have a right to a fair and meaningful hearing here today?
Yes.
Thank you, Judge. Do I have the right to be informed of the cause and nature of the proceedings here today?
I'm just going to object. There is a proper procedure for a courtroom that's very well stated in Texas Code of Criminal Procedure. Defendant is not following any of those rules. State feels this. As far as motion to dismiss has been ruled on. As far as the state, Your Honor, we did have a motion for discovery. We have 2 complaints and the police report, the full police report to hand over.
All right, if you'll have that to come. All right, so as I've stated previously, the motion to dismiss is denied.
What grounds again?
That the court does have jurisdiction.
And what evidence do you have that the court has jurisdiction?
That will be determined at trial. The state will basically, what a trial is, the state.
So you're going off just a presumption right now that what you're doing might be ethical? So you're saying you're going off of a presumption where it could be wrong to impose here today. Is that correct?
The affidavit on file is what was used in the argument for the state's response to your motion to dismiss. That motion to dismiss has been denied. I don't know how many more
Just because someone
times.
asserts something doesn't make it true.
Your Honor, we object again that asks the defendant to follow
Correct, yes.
procedure. If he's going to keep arguing, at some point the state would like to have a counter argument. The court has ruled that it's been dismissed, Your Honor. We feel that.
Okay, so the court has ruled that the motion is denied.
Well, there's no arguments going on.
Okay,
I'm simply trying to clarify a few things to find out how I need to go about here today. I didn't go to 30 years of law school. I didn't go to Harvard. I'm simply trying to clarify to find out if I do need representation, if I need to represent myself, if I need to defend myself. But the only way for me to come to that conclusion is if I get these clarifications answered or responded to. And the clarification that I'm looking for right now is, am I presumed innocent of the allegations here today?
Yes, you are.
Am I presumed innocent of all the elements of the accusations here today?
Okay, hold on 1 second. I've already denied your motion to dismiss. The hearing is over. The hearing is closed. If you would like to plead guilty, you can let the clerk know. If you want a trial date, we can get you a
Does this
trial
court
date.
accept uninformed guilty pleas, Judge?
Okay, the hearing is over. Okay.
Does this court accept uninformed guilty pleas? Are you guys threatening me now? Are you threatening us?
Raymond, leave.
Just.
Do you want to leave on your own?
Raymond, check
I'll
out.
leave on my own. If you guys are going to threaten me, I'll leave on my own.
What is violence? It shows that every day. How do you let violence like that in your court, Judge?
Violence in the courtroom. Violence in the courtroom. You guys see that? Violence in the courtroom. It doesn't matter. Look how many people are here. This is a public area. Now we got this guy behind us trying to be a thug.